Okay, everybody. Hey, how are you doing? It is Brian Foley. I'm with Houston Criminal Defense Attorneys, PLLC, and today we are talking about Texas Penal Code 9.32, deadly force in defense of person. Okay, and so I think every time a lawyer talks about this subject, the first thing that we should say is that do not watch this video and then kill somebody because you think you're justified based on what you've heard in this video. We are going to discuss, the circumstances in which somebody is justified, but do not just watch this video and then feel like you're justified in whatever you're doing. So this is not legal advice. This is just educational material about this statute, okay? So having said that, in the Lone Star State, Texas, the right to defend yourself is enshrined in the penal law, in the penal code. It is not a free pass to escalate violence without limits, and Texas has some of the strongest self-defense statutes in the nation, including the Castle Doctrine, which empowers an individual to protect their home, vehicle, and themselves. At the heart of this framework is Texas Penal Code 9.32, which is deadly force in defense of person, meaning like your person, yourself. And if you've ever wondered when you can legally use deadly force, or if you're facing charges after a self-defense incident, this video is going to break down step by step how we would look at that issue. The bottom line is you better be afraid that someone is going to kill you right now or commit serious bodily injury right now. Prospective threats, threats in the future, and verbal provocation alone will not cut it. We have helped people with this kind of thing before in the courts in Harris County and other counties, so we're going to start looking at this. First, before deadly force comes into play, Texas law requires that your actions start with a baseline of justified non-deadly force under 9.31. You can use force against someone if you reasonably believe it is immediately necessary to protect yourself from their unlawful force. Deadly force builds upon this, and it is the next level when the threat escalates. In short, you can't jump straight to lethal measures without reasonable fear of unlawful deadly force being used against you. But once that threshold is crossed, Section 9.32 provides clear guidelines. The core of the statute states that a person is justified in using deadly force if two conditions are met. First, if you would be justified in using non-deadly force under 9.31. That means that the other person is posing an unlawful threat that warrants some level of response. And then two, that you reasonably believe deadly force is immediately necessary to protect yourself from the other person's use or attempted use of unlawful deadly force. Example, if they're coming at you with a weapon, you think they're going to stab you, you think they're going to shoot you, you think they're going to hit you with a lead pipe, right now. Or if it's to prevent the other person's imminent commission of serious crimes like aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. The key word here is imminent, and the threat has to be happening right now, not a vague future danger. And then the words reasonable belief, those are judged from the perspective of the person in the heat of the moment, not with 20/20 hindsight. So you don't suggest what would a normal person do like later on after thinking about it. You think, what would a normal person do right then while the person's coming at them with a knife, etc. The Castle Doctrine is 9.32b. This goes further with a presumption that your belief in the necessity of deadly force is reasonable. And this presumption kicks in if you knew or reasonably believed that the intruder had unlawfully and forcibly entered or tried to enter your occupied home, vehicle, or workplace. They unlawfully and forcibly tried to remove you from one of those places, or they were committing and attempting one of those serious crimes from Section A to B. You also cannot have provoked the confrontation. You can't say, hey, come over to my house so I can kill you, and then they break into your house, and then you try to argue Castle Doctrine. That's not going to work. And you can't be engaged in criminal activity at the time. So if you have a meth lab in your house and somebody breaks into your house, it's a serious question as to whether or not you're going to have the ability to have this Castle Doctrine because you are engaged in some criminal activity. The prosecutors, if we've shown all that, now have to prove that the belief was unreasonable rather than you proving that it was reasonable. This is an affirmative defense. You have to show by preponderance of the evidence. You have to get the burden of production of this defense. But once you've made the defense, then the prosecutors have to disprove it beyond a reasonable doubt. And again, you have no duty to retreat. So just looking at the raw language of the statute, a person is justified in using deadly force against another if the actor would have been justified in using force against the other person under the regular self-defense statute, and when and to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. Now, again, when I go through that, when I say actor, I don't mean like Tom Cruise or, gosh, that just makes me sound old, right? Who's a good actor nowadays? Tom Holland, let's say. I don't mean Tom Holland. I mean the person who is accused. It's going to be the defendant in the criminal case. The actor is the person who's using the justification, defense, and deadly force. So again, that list, it's important to know this list. To prevent the other's imminent commission of aggravated kidnapping, meaning kidnapping somebody with a weapon, murder, sexual assault of any kind, aggravated sexual assault, robbery, or aggravated robbery. Notice what it doesn't have here. It doesn't have burglary of a habitation. Now, we may have another statute that is going to cover that, like protection of property at night, deadly force to use that at night, but that's going to be a separate section. So don't think that this section is going to save you if you're trying to prevent burglary of a habitation. It's got to be like the house is occupied and that becomes a robbery, right? You think it's going to be a robbery or an aggravated robbery that they're committing, or maybe aggravated sexual assault. But it also just includes sexual assault. So if you find somebody, or if you believe they're about to try to rape you, they intend to do that, they say that, and then they come towards you, well, bingo, you're going to have the ability to use deadly force to prevent that under Section 2B. Okay, I think that is pretty much the law here for Section 9.32 when deadly force is justified, right? You can, unless they are really, really bad and it's very clear that they were about to use deadly force against you and it's imminent, then you're not going to be able to use deadly force. If you can say that it's imminent and it's a reasonable belief that you think they're going to use deadly force against you, then yeah, you can use self-defense. You can use deadly force in self-defense. Let's go over like one example when this comes up. There's two. Let's go over two. Let's say you're in a bar fight and you are in this fight with this guy and he is coming at you and he does not have a weapon and he's just repeatedly hitting you, but you finally get the upper hand, you get behind him and you have him in a chokehold and he is continuing to fight and fight and fight and you're just holding him on in this chokehold until he relents, until you feel like you're safe and you have no intention to actually kill him, but turns out he doesn't relent until he actually dies. And now this person is deceased. You have been acting what you think is in self-defense, but you've used deadly force and you're not really sure whether he had ever really come at you with deadly force or not. That happens all the time, actually. And this is the kind of case where people get charged with murder on that very, very frequently. And the defense is going to be that was it immediately necessary to use the chokehold? And was that person really presenting deadly force? Okay, because you used deadly force. Whether you intended to or not, you used it because he died, right? That's going to be the law there. In this situation, if you let go of this guy, is he going to come back up and kill you? I think it's going to depend on like your height weight differences. It's going to depend on, in reality, folks, what happens in these trials is it depends on like how the other actions of this defendant or the alleged victim are that night, and who does a jury think is really at fault. If you're in a small town, is this person well known in the small town? Like, these are things you're going to have to actually consider in real life that have nothing to do with the statute. So that's probably the most likely incidence of this statute coming into very sharp application of whether or not this was really imminent. The person didn't have a deadly weapon, but were they using their hands as a deadly weapon? Or was their actions and words, like did they say, I'm going to kill you as they rush towards you in the bar? Something like that is going to be helpful in trying to show that the deadly force was immediately necessary. I think that's probably good. we'll follow up on this one. We've got some other statutes here to cover, but thanks for everybody for tuning in. We will see you next time. Don't forget to like and subscribe. And if you enjoyed this video, leave a comment if you have another video you'd like us to cover or another statute or something like that. And we will see you next time.